Welcome to the Live Full, Work Fun podcast. This is the show to encourage you to live your life to the fullest and do fun work that fuels your lifestyle. Hi, I'm your host, Gayla Scrivener. Every week, you'll be introduced to amazing guests, useful resources, and inspirational stories. You'll discover opportunities and perspectives to shape your version of living full and working fun. Hi there, and welcome to the show. If this is your first time here, I am glad you're tuning in for the very first time. Thanks for checking out the show. And if you're returning, well, welcome back. It is always a delight to have you here. Are you a part of the Live Full, Work Fun community yet? If not, be sure to hop over to Facebook and join the Live Full, Work Fun group. Today, I'm excited for you to meet Stephen Thrasher. He's known for helping create his clients' intellectual property fortress. Stephen is an engineer, inventor, entrepreneur, and attorney. When he was in college, he had a really cool idea for an invention, but had a terrible experience when it came to figuring out the whole patent process. The way I see it, he was scammed for a whole lot of money, and his invention was still not protected. Because of his experience, he was bound and determined to help out other budding entrepreneurs to avoid feeling the way he did about his intellectual property, lost and unprotected. He went on to law school to learn more about the nuances of IP law and has created his own system helping small businesses with protecting their inventions and intellectual property. He stops competitors from stealing your customers and keeps your online business from being the victim of a takedown notice or copyright troll attack. He does this while running marathons, hiking up mountains on remote continents, and building his own online businesses and information products. If you see him on a laptop on the rim of the Grand Canyon, he might be in the middle of working on all of these things. My conversation with Stephen was full of great info of not only what we should be aware of when it comes to our intellectual property, but also we take a peek behind the scenes of why he chose to leave a big law firm in lieu of creating his own practice. Thank you so much for being here with me today. I am so happy to see you again. It's been a while.
Yeah, Gayla, it's an honor and a pleasure. Thank you for having me.
Well, from the intro that I've already shared, you're an IP attorney who could be fighting trolls with your laptop on the rim of the Grand Canyon. And I'm just curious, tell me a little bit more about yourself. And have you always had this type of work from anywhere lifestyle?
Wow. So the second part of that question, have I always had a work from anywhere lifestyle? The answer is no. Frankly, when I was young, I just wanted to work. From knocking on doors to pet sit and mow lawns when I was barely in junior high school and had to push a lawnmower by, pushing from about my shoulders. I've just loved doing services and, of course, getting paid for it. I definitely had a much more traditional career path. I originally was targeting engineering, switched from there to being an attorney. And that's where the tie to intellectual property law comes in, largely from patents. By the way, I have my own patents. That led me to begin a career at a large law firm. I mean, that's hardly anything close to work from anywhere. They're constantly telling you where to work, when to work, how to work, how to march with your little finger down the, seam of your trousers kind of stuff. Probably like most of your listeners, that kind of regimented lifestyle rubbed me wrong. And it just felt so limiting in so many different ways. And so after working at a large law firm for nearly 6 years, about 6 years, I left and started my own law practice that gave me the freedom to work, more when I wanted to back then rather than where I wanted to. The internet obviously has helped people work where they want to now. But it also gave me the freedom to pursue other businesses and other ventures. And so just the entire spectrum of flexibility is what attracted me to be my own entrepreneur. Today, I have a intellectual property business that is geared toward helping online entrepreneurs and startups, similar to yourself and your audience. And so I help people who have online businesses identify their trademarks, their copyrights, elements of their design presence that they need to protect, and also help them evaluate whether they can use it at all without being sued or receiving some kind of cease and desist letter from, say, Getty Images or some other company. I help businesses that are large and growing, primarily in the technical spaces. So I have clients that are in alternative energy sectors. I have clients that are in the railroad industry. I have several clients that have different software businesses. All of these groups of clients tend to have more of an invention focus. And these are clients that usually have between 5 and 30 employees. And so that's, completely different from the kind of client that's the online business and startup. Online businesses and startups are kind of a passion of mine because, that's me. So I have those two groups of clients. And then I have a few startup software businesses that I'm working on as well. So, without the kind of lifestyle that being an online entrepreneur affords, I could never have the ability to pursue these different interests.
I love that. And there's so much that encompasses law. So, and you mentioned that one of your passions is the online realm. What draws you to IP, trademarks, copyrights? What draws you to that online space?
When I was at a large law firm, I would receive calls regularly from people who are just trying to start a business, just trying to do the right thing. And so frequently, they were either picking brand names that I knew would get them sued, or they had developed a product and had not gone about protecting it correctly, or they thought they had filed for a trademark, but they filed for it incorrectly, and that just wasted their time and money. And I saw them making all these mistakes, but at a large law firm, just to call us, and this is, over a decade ago, we were told to ask for $10,000 or $20,000 up front. And so it just created this barrier between the law and the individual entrepreneur. Now, those barriers have come down in a lot of ways, but some of those ways those barriers have been reduced have been good, and others have been, frankly, kind of dangerous. One of the jokes I make about my services is that sometimes I call them the legal Zoom repair kit, because so many people create so many problems for themselves thinking they can do it on their own. Your listeners might be familiar with the Dunning-Kruger effect, where people will read a blog or get started in a book and they'll think they know enough about how to protect themselves. They'll take a few steps down that path. And the next thing they know, they are falling off a cliff of mistakes, of problems, of maybe they file for a trademark without doing a trademark search. And in the process, they alerted several businesses that do have trademark registrations about their presence. And so what happens next? They get cease and desist letters and demands for money from these companies telling them to stop. If they talk to a professional first, and we start with a trademark search, those are pretty predictable. And I'm able to tell the client, hey, pick a different name, or make this change, or let's characterize it this way, and just keep them out of trouble. So broadly speaking, I will frequently talk about what I say bucket one issues and bucket two issues. Bucket two issues are the questions most entrepreneurs think they want to know the answer to. Can I register this mark and make it my own? Can I register a copyright and make it my own? But they skip the bucket one issues. The bucket one issues are, can I even use this thing in the first place without getting sued or getting a cease and desist letter or a demand letter? And so to address bucket one issues, we usually start with trademark searches. There's some other things we can do there as well, such as an intellectual property ledger. And then we move to the bucket two issues, which are, how do we take the stuff you've developed and capture it to make it your own, to make sure that your ideas and your brand is not stolen and plagiarized.
I'd like to kind of stop or go backwards just a little bit. What the difference of a trademark is versus a copyright versus intellectual property. What's the difference?
Sure. So intellectual property is really a broad category of rights, of intellectual property rights, of the rights you have to the thoughts of your mind and the ways that you convert them into something tangible in the real world. So intellectual property rights include trademark rights, copyrights, trade secrets, design rights, some other stuff, but those are the big ones. Patent rights, for example. So then let's break those down a little bit. Trademarks protect names, slogans, and logos that identify a product, a service, or a company. They're identification mechanisms. Famous ones that you know, and of course the audience knows. Nike, the swoosh, right? Just do it. It's a slogan. It's trademarked. McDonald's, the word, trademarked. The Golden Arches, a logo, trademarked. Coca-Cola, the word, trademarked. The word that stylized Coca-Cola, that script, trademarked. The look of the red can, trademarked. The look of the kind of feminine glass bottle for Coca-Cola, trademarked, and interestingly, trademarked as a design right.
Is that like John Deere? Do they have John Deere green and John Deere yellow? Can you trademark a color?
Well, you can trademark a color in certain circumstances. UPS has tried to do that with brown. Owens Corning did it with pink fiberglass. So color can be an element of your branding, and sometimes color can give rise to that design right that I alluded to a little bit earlier. I would actually have to look to see if John Deere has filed a trademark separately for the color green as it relates to, say, tractors, or I think Kubota's red, for example, to just see if those are differences, but that have been registered. But getting a color registered for a brand is rare. The way Owens Corning did it is they actually added pink to a product that is naturally brownish yellow. And it was this unnatural, unnecessary change. So if you see pink insulation, it is definitely Owens Corning insulation.
That's interesting.
Also, by the way, sounds can be trademarked. The sound of a Harley Davidson motorcycle is now a trademarked sound.
How interesting. I love that you help online entrepreneurs. And especially with COVID, there's been so many people that are trying to make a go of it in the online space, a lot more than what it had been in the past. Talking about copywriting and trademarks and IP, just getting started and thinking about that stuff, it's kind of scary. First of all, am I going to do something to get a cease and desist letter? Do you have one thing that a good practice would be for a beginning online entrepreneur just starting out, maybe in regards to, probably wouldn't it be images that you would use on your website or in social that could get them in trouble?
Yeah. So one of the easy, if you will, suggestions is to keep what's called an IP ledger or intellectual property ledger. This is a spreadsheet that just lists the elements that you have on your website and marketing materials and other digital content and printed content, if you have any. And you identify where it came from, the date that you got it, and the natureship of your ownership. So those are each different columns. You want to make sure that when you use an image, you're able to demonstrate that it came from a particular image library, and you want to identify the license that came with that image library. Now, you don't have to get super specific on that. You can just say, for example, I use deposit photos for most of my images. I just list the deposit photos image library license just by name on it. Fortunately, I haven't received any, but if I individually received a letter that said, hey, pay us for that image, I can immediately go to my ledger and say, no, here's how I track this. Here's where I got the image. Here's the license I have it under.
And you could pull up your deposit photo account and find it in your paid type stuff. That's very good. It'd be very similar. A lot of my audience uses Canva, and Canva has a similar type of repository for images, and some of the images are the same as on deposit photos.
Yeah, and I use Canva as well.
And you also have there's pro accounts. So if you use a Canva account and use the images provided to them, that's the same type of thing, right? Then you can just say in your ledger that this is it, where it's from. If you have a photo shoot with somebody, would you put in your ledger that it was from this photographer?
That's right. And you want to record the nature of the ownership and the nature of the use. So here's something that's critical. When a video is made or photographs are made, the person who is recording is the owner of that content. So Gayla, at this moment, you're recording the audio of this podcast. You are the owner of this content, not me, even though I'm the one talking to you right now. If you use the video content of this, you are the owner of that video content. So when somebody's taking photographs of you, they own the content. Go to, say, a wedding photographer. Wedding photographers make it so hard to pull down photos without having those watermarks all over them. Well, that's because they own the photographs until they are paid for them, in which case they release them for some license, right? They don't let one person buy the photographs and then distribute them to all their friends. They require downloads from each individual use. And wedding photographers and other professional photographers monitor that content like crazy. In fact, some of them are my clients. Be sure that you're aware of the kind of license that comes with the photographs that are made, or even better yet, if you have control of the contract, make sure that it says that you're the actual owner of the photos made during a particular photo shoot.
So on the flip side, kind of on the flip side, many of my listeners are creatives. So they're taking their own photos or they're doing their own thing, and they may put it up on different websites or just on social to share. What if somebody else grabs their photo to use on their website?
That's just a straight up copyright infringement.
Some folks will just Google an image, and then on Google, sometimes they say that there is some copyright stuff, but I can't even think of the site right now. It's kind of it's eluded me. Yahoo owns it, but it's an image site. Sometimes their stuff just looks like it's like free to anybody to use, but it's not.
This is actually one of the most common scenarios I assist business owners with, and that's when they get a cease and desist letter or a demand letter for $3,000, $5,000. Biggest I've ever seen is $60,000 for using an image that a contractor they hired, maybe in the Philippines, maybe India, maybe Kansas, just did a right-click download from an image that they found on a Google search, a Google's image search. So here's a dark side of copyright trolls. Now, we talked about brands and trademarks a little while ago. Let's get in the world of copyrights for a moment. Copyrights meaning artistic creations, the text of books, images that are in books, whether they're hand-drawn or photographs. We're talking about videos, audio recordings, presentations of speeches, even sculptural works. All of this stuff lives in the realm of copyright law. So it's common for there to be, as you mentioned a moment ago, image libraries as well as audio libraries and video libraries. What some companies we call trolls do is they take images or videos or audio from their libraries, and then they associate it with a blog article that they have written. And so this happens every year around, in fact, this time of year, Christmas, New Year's, somebody will publish an article and it will be on, I'm going to pick something from intellectual property. It will be on patents related to Christmas ornaments or patents related to Christmas trees. And if I do that kind of a search, I will find a blog article inevitably, and it will have patents on Christmas trees, patents on Christmas ornaments, and the images have been altered just a little bit. And so what they'll do is they'll take a patent, which is a government image and therefore not copyrightable, but then they'll apply, say, an aging filter to it, kind of give it this old, classic look. Just by doing that one little change makes that a copyrighted image for that company. Then they will SEO that blog so that those images appear very high in search results. So they're laying that trap. So if you as a user go in and search for images like those, and then you or a contractor just quickly downloads them and then uses them on a website or a blog of your own, or even a Facebook post, boom, that image library just was able to trap you into using their image. Now they have a web crawler out there also that goes around and looks for little, what they call pixels. And also sometimes these images have what are called beacons in them, and they find that image, and they have this automated system that captures the image and then sends you that demand letter for $3,000 or $5,000. To me, it's cruel because it's usually catching young people using these in school projects.
Well, what if you discover one of your images? I'll just give you an example. My husband and I were searching the web in this little tiny town where I grew up. And there's not very many pictures of this town. And there's a new business, a new campground in that town. Lo and behold, on their homepage was one of my husband's pictures that, first of all, was pixelated, and that drove him nuts because I knew that was, a screenshot or right click, save a thumbnail, but it was pixelated, but it was his image of a landmark in that little tiny spot in the road. We ended up calling that campground and made a friend along the way. But yes, at first we were kind of offended. We were offended, and that campground said, well, the owner was like, yeah, I designed the website and I am a graphic designer, and I took the image legally from a site that said that it was without rights. And I was just like, no, that doesn't seem right. It just doesn't seem right.
Yeah, Google has this filter for images that are rights protected versus ones that aren't. That filter is just, it's an automated tool. It's not definitive. Most people, if they discover they're using an image without permission or one that's not in the public domain, those are public domain's magic words, most people just bring it down, take it down if you complain about it. Others, will offer you a little bit of money.
In the grand scheme of things, it's kind of flattering, but also as a creative, my husband's a landscape photographer in one of the many things that he does. But with that, it's kind of flattering. So we want to make friends and have him linked and credited. That's our biggest deal, because we usually, when we had, one of our images was in an RV magazine. And it was just like, yeah, we didn't give permission for that. What's up with that?
Well, and like most creatives, if you're given attribution, that's 90% of what you're seeking usually. The thing that's changed since I started practicing law has been the advent of social media. And with social media, we've seen just the proliferation of everything. That share button, quick content throw up, on post, replies to post, using images, using graphs, using, the creation of GIFs. Some are funny, some are satirical. There are just all these creative elements that are being thrown around the internet so quickly. If you're a content owner, what you should be doing is looking at two things. One is what's called a rights management system. And then a second thing is for content that you produce that ultimately will distinguish you from other people in your business, and make you money. Do consider registering that content as a copyright and register it within 3 months of the publication to ensure that you get the most rights that are available to you. If you wait until after 3 months of publication, your rights under copyright law start to diminish to the point where after 5 years, the only right that's left is the right to sue and recover actual damages. If you file for the copyright registration within 3 months of publication, you get rights to, in the event of an infringement, attorney's fees, court cost, presumption that everything you put in your registration statement is true. You get the right to a preliminary injunction. I'm sure that there are other rights I'm just not thinking of off the top of my head, but the point is you get this bundle of stuff, right? And what is a registration other than the rights that come with it? So if you register your copyright quickly, you get all the rights you're entitled to. If you wait, eventually there's only, this little right you're entitled to. By the way, I'll distinguish that from patents. With a patent on an invention, if you wait more than a year after your invention becomes public in any way, you've lost the right to file to protect that invention forever.
So do you need to, or should we be aware to copyright lead magnets?
So some things that digital entrepreneurs frequently copyright include things like their website, their lead magnet, like you just identified, their processes that they use in their business, particularly with coaches. So coaches typically have systems that they're either licensing through some coaching program or that they've developed on their own or some hybrid. And so coaches that have programs that are strong and that they've developed unique aspects to, the written material that they use to implement those should be separately registered as copyrights because those are valuable business assets.
And so is there a formal process to registering those things, or do you have any advice on resources to check things out before coming to see you to help register?
So for trademarks, you can sometimes do some what I call spade work, some initial work on, say, trademark searches through the Trademark Office website. That doesn't search for state registrations, that doesn't search for common law uses. If you want to go deeper on a trademark search, call me or call another trademark attorney. On copyrights, it's much less about doing a search because searching copyrights, frankly, is kind of hard. There's this concept in copyright law because copyrights are creations, right? If you independently create something, it is presumed that you did not copy somebody else. So there's this rule, it's called the independent creation rule, that says if you independently created this thing, you own it. Now, if you are looking at some other person's work and you're over here trying to derive your own version of it, that's different. That's something called a derivative work. That can get you in trouble in some circumstances. So call a copyright attorney first. But to register either a trademark or register a copyright, there's a phrase I hear frequently amongst attorneys that are IP attorneys: filling out a form is easy. Filling out a form correctly is really, really hard, particularly for trademarks and copyrights. So when you're ready to register your trademark and you're ready to register a copyright, call a trademark attorney, call a copyright attorney. And especially with copyrights, if you don't file it right the first time, you may miss this 3-month window or the other time windows that exist, and then lose rights because it wasn't filed correctly the first time.
So on all the website builders, there's an automatic thing in the footer that says copyright that goes down there. So that's not meaning that your website's copywritten.
Well, okay, so that deals with this concept called notice or intellectual property notice, trademark notice, copyright notice. For copyright notice in particular, it's stating that you are claiming as the content creator rights to that creation insofar as you have them. right? It's identifying you as the owner. It does not mean that it's registered. So in fact, I tell my clients, and this is what I do for my own work, if I have something registered, if a client has something registered, I will state copyright registered 2021, copyright registered 2022. Then it's your name or the name of the entity that owns that right, the city, the state, and the nation if it's dealing with something international. And then I usually include a zip code as well, just to make it crystal clear that this is how you find me.
Nice. Now, all of this stuff can be intimidating. There's a lot to it. Should it scare us as creatives to stop us from creating and building our online business?
No, I think the scariest thing is marching ahead and being blind and playing ostrich to this stuff. There's a phrase I heard earlier today: playing business is dangerous. If you're in business, be in business. Playing business and thinking you could ignore certain rules, like say filing your taxes or filing certain government registrations, that will get your business shut down. Not paying attention to intellectual property may get you cease and desist letters and demand letters, which aren't much more fun than getting a letter from the government, right? So as a creative, recognize that to be in business means doing things right, frankly, so you'll get paid for it. So why wouldn't you want to do it right? And doing things right means you won't get sued, or you won't get a cease and desist letter, or if you do, you know how to deal with it. I'll give you an example from a client that's talked about this publicly. One of my clients is a guy named Mike Kim. Mike's well known in the marketing space, and he recently had a book and a program come out called You Are the Brand. On the verge of the launch of his product in his book, he received a cease and desist letter. Fortunately, Mike was a planner, and so we did the searches months earlier. We mapped out what might happen, and we had a plan to respond to it. And lo and behold, one of the less likely scenarios is actually the one that happened. But we had already planned, well, this is how we respond to it. And we were actually able to use that cease and desist letter to get his trademark approved faster. And so now he has a trademark registration for You Are the Brand. By the way, his book is copyrighted, and the images in his book are also copyright registered. And also some of the program material that he has that he uses in his online program for teaching the concepts that are part of You Are the Brand are also copyright registered. And so what he's done is he's built this entire umbrella around his framework. So not only is he now creating a identity as Mike Kim, he's also kind of known as the You're the Brand guy, the personal branding expert. And so that helps him from a brand perspective and from a monetization perspective.
He did research before. You guys did research before, and this little troll kind of came up.
Yeah, so remember, there are the bucket one issues and bucket two. Bucket one is, can I do it without getting sued or a cease and desist letter? And if it happens, what do I do about it? Bucket number two is, can I register it and make it my own? The way to answer both of those questions before you actually spend the money to file is to do searches. So we started with the trademark searches on You Are the Brand. We identified companies and businesses with similar brand names. And then we said, well, what might happen? And if they take some of these actions, there are different actions that might have happened, then how will we respond? And so we already had a plan in place. So we knew how to take care of those bucket one issues. Bucket two was, okay, can we register these rights and make them your own? So to do that, we put in place assignments so that the image creators for the images that are used in his book, he owns those. And so he wrote the content, unlike some authors, by the way. All that was his. And so he has authorship. We went ahead and registered that as well. And we captured the brand, the content he's selling, give him a way of making his frameworks that he teaches within the You Are the Brand program, what we did was we set those up so that they could be protected.
Good deal. Now, I know that you have a resource because there's a lot that can be encompassed here. And you have a resource that listeners can download. Can you tell us a little bit about that?
Sure. So I'm going to post several things for your listeners to be able to download and come visit. The free resource that you're referring to is the 7 Deadly Sins of Online Businesses. And to get those, all your listeners need to do is to go to thrashlaw.com/Gayla Scribner. So thrashlaw.com/Gayla Scribner. And they will see the PDF on the 7 Deadly Sins, which covers several of the mistakes that we discussed, plus a few others, as well as an IP ledger. And if I can think of a few other things that might be of interest, I'll throw those in there as well.
That is fantastic. You have been a world of information. I won't lie, a little scary, but it is so great on how you can break it down and make this big issue that could be an issue not so scary, that having a friend like you can get through a scary letter of a cease and desist. Having the knowledge and getting to know you just helps. I love how you explain what I think is complex information in a nice way. So I appreciate that.
Well, thank you. And to me, it's being in business that's scary. What I do is I'm kind of like the red light, green light, helping guide you through the intersection. But it's actually being on the road without any traffic signs that's probably the most scary part.
Being in business, I typically ask my guests what has been like the best resource or book that has really made a difference to you. I've been throwing out there either mainly professionally, but also throwing out there personally. What's been a great resource for you?
I actually came prepared for that question because I heard you mention that on a couple of your podcasts. So books that I just draw inspiration from include Meditations by Marcus Aurelius.
Ooh, okay. Good deal.
One of the concepts that he talks about is implementing an idea. And that was a theme on one of your podcasts recently. Implementing an idea is hard, right?
Boy, it is.
In that regard, another book is Michael Hyatt's Full Focus Planner, which is not really a book you read, but it's kind of your plan for action. And I love how, and I'll tie it into Marcus Aurelius, you are your habits, and habits are hard to create and hard to stay true to. I mean, if they were easy, everybody would exercise and eat right every day. But with the Full Focus Planner, it makes keeping up with the schedule easier. It makes keeping up with your task list much easier. And I will tell you, since I started using it about 3.5 years ago, I have been noticeably more productive, and I make fewer mistakes in my businesses. As we discussed, I'll add You Are the Brand by Mike Kim to that list, as well as Expert Secrets by Russell Brunson.
I like that one too. Mm-hmm.
And then the odd book I thought I would mention is a book by an archaeologist, David Roll, called A Test of Time. And here's why I find that book interesting. We, as individuals, rarely test our presumptions. But David Roll, in researching history, discovered mistakes made by archaeologists, and those mistakes led to what we call the Greek Dark Ages. To him, and I think he's right, they're a myth.
I love all of those resources. Well, thanks, Stephen, for sharing so much today. It has been a pleasure.
Likewise, Gayla, it's been a thrill. I appreciate it.
Now, before we go, I want you to share and make sure that everybody knows how to get a hold of you and how to follow you.
Sure. So your listeners can go to thrashlaw.com. I have resources there. My contact information is available there. But for your listeners that want to contact me directly and maybe set up a consultation, they can reach me directly at SW, as in Stephen William, Thrasher, my last name. By the way, that's not my website. Thrash, THRASHLAW, Thrash Law, but my last name's Thrasher, SW Thrasher at gmail.com. Comes to me directly. We can set up a time to talk, maybe explore working together.
Awesome. Well, thank you so much. And I appreciate you being here today.
Thank you, Gayla.
Well, thanks for being here today. This conversation with Stephen has gotten me thinking about a whole lot of things, actually. I can't help but feel a bit overwhelmed by the whole subject. I am so glad he shared so much. Now, be sure to scroll down to the show notes for his contact information. I've also listed his YouTube channel as well, because I had a chance to peruse some of that, and those videos are so useful. So check out his YouTube. Well, let's continue this conversation. Hop over to Facebook and post what your biggest takeaway from today's show was in the Live Full Work Fun group. I do hope you enjoyed the episode and you found it helpful. And I would love for you to do me this one tiny favor. Be sure to share this episode with at least one person who you might find it helpful and enjoyable. Just text them the link. Well, thanks again for listening. And until next time, have a fantastic week. Live full and work fun.